الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وعلى آله وصحبه. Jazakallah khair for all of you for attending the program. So just a brief introduction of what has been planned or what has been going on in the background. So first of all, I'd like to thank Chris for coming and partnering with us in presenting this workshop. And so I'll leave it to Chris to actually, give us a background of himself and his qualifications. But suffice to say that if you look at his ratings on the internet, he has very good ratings. And I've interacted during my experience with regards to estates and dealing with attorneys. I've dealt with probably over 100 attorneys when dealing with various estates, not necessarily in the United States, probably it's limited, but definitely in South Africa and back home, we've dealt with many attorneys. And I found Chris to be one of the very few well-qualified people in the sphere of estate planning and also the drawing up of trusts, which I think is very crucial, especially considering the death tax that becomes applicable on most of us or most people who have a considerable amount of assets. Chris also was very quick to learn the various aspects of Islamic law, and we had worked on actually one template or one particular case which I would assume would form the template for future trust deeds. And from what I've noticed in the trust deed is that it has been structured in a very flexible manner which would be able to accommodate Islamic law as well. So we've had multiple clauses included, and wherever there was something that needed to be changed, we changed it. A good few, I wouldn't say good few hours, rather a good few days actually, if you have to count all the hours together, went in actually structuring, studying this, putting it together. From Chris' side, I don't know how many days he had spent, but from just my side, just after looking at it structured and then adding comments to it, studying it, I would say a good few days went in that procedure. And Alhamdulillah, we've reached the point now where we are able to actually use that as a template and to move further or to assist people with regards to drawing up their trusts or forming their trust deeds, as well as their Islamic wills or the wills that will be in accordance to Islamic law, and will assist people in having their estates distributed according to Islamic law. I found in multiple places that we've always qualified something that it must be done in accordance with Islamic law. It must be distributed to the heirs according to the laws of Islamic succession and inheritance. And then even we've added the clause where if there is any dispute, then the matter would be referred to a panel of Muftis or a credible Islamic center, which will then determine the shares according to Islamic law. So these steps have been put there so that it ensures that a person's estate is distributed according to Islamic law. At the same time, it will facilitate for the person's estate to be distributed within the framework and within the bounds of Washington state law, or depending on wherever a person is residing. And Chris has various qualifications, or is authorized to work in various states, and he has experience in that as well, which we'll come to know when he gives us an introduction of himself. From my side, just it's not to blow my horn, rather it's more to emphasize on the work that has been put forward and the value of the attorney that we have in front of us. Is that I wouldn't say, or I could safely say that I've dealt with over perhaps close to 1,000 or at least over 800 estate matters during my time in the Jamiat al-Ulama in South Africa, which is based on a secular law, or you can say British law, which has a lot of resemblance to the laws that are here, with a few differences here and there as well. And what I understand from this, or what I've gathered from my experience with Chris, is that definitely these things are doable. It is very doable to have our estates distributed according to Islamic law. And the importance of it comes about, one is with regards to a person being taxed when he passes away, the estate duty or the death tax that comes about. we must understand from the Islamic point of view that definitely there is no harm in that money going, as it should be according to the laws of the state. But at the same time, we understand that when a person leaves this world, then that money now belongs to his heirs. Like how you would be desirous of protecting your own wealth, you also have to take provisions and take steps to protect the wealth of others. Because now once you leave this world, you've got to be concerned now that this wealth now belongs to my mother, this wealth belongs to my father, it belongs to my wife, it belongs to my children. They have a right in it. So what is the best way to leave this wealth for them? In the hadith of Sayyidina Abu Sa'id al-Khudri radiallahu anhu, we understand that Rasulullah sallallahu alaihi wasallam had emphasized on the rights of the heirs. And Nabi sallallahu alaihi wasallam told him he wanted to bequeath all his wealth. And Nabi sallallahu alaihi wasallam, the Prophet of Allah sallallahu alaihi wasallam, told him that you cannot do this. You should be considerate of your heirs or the people who will survive you. Make sure that you leave something behind, and it is better that you leave something behind for them. It is better that they maintain independence instead of them being left without anything, where they now have to extend their hand for assistance to other people. And then he wanted to distribute or bequeath half his estate, and the Prophet of Allah sallallahu alaihi wasallam told him that that too is too much. And then he came down to 1/3, and the Prophet of Allah sallallahu alaihi wasallam allowed 1/3. But he also said, "Thuluth wa thuluth kathir." That 1/3 that is fine, but 1/3 also is a lot. But at the end of the day, it is allowable, and it is something that I would permit. So what we understand from here is that we also have to be concerned about the wealth that we will leave behind. Number one is it must be distributed according to the laws of the Quran, according to the laws of the Sunnah. At the same time, we must be concerned of how we can give the most benefit to our heirs. And this is why we come to the aspect of drawing a trust to ensure that there is a very smooth procedure that is followed when a person passes away, and Chris will be able to advise on that. At the same time, it makes money accessible. If a person has to become incapacitated in his lifetime, there is benefit to that as well. Where his affairs now, he has somebody who is appointed to handle his affairs, and that person now, the transition can happen in a very smooth manner. Similarly, a common complaint that comes when a person passes away, then although he might be worth millions or he might be worth a lot of money, because that money is inaccessible, what happens is that with regards to his burial and with regards to his funeral expenses, that money is now inaccessible for him to be buried. And as a result of that, sometimes because the person living alone or person does not, nobody has access to those funds, they are unable to reach those funds, and as a result of that, the funds have to be drawn out from a common fund or from a public fund to assist the person, which is sadaqah. And many a times that fund now, or the amount that has been borrowed from that fund is not replaced, or it is something which is not returned. So these are various aspects that come about when we do not leave proper provision for our will and our estates to be planned. One is in accordance with Islamic law, at the same time taking into consideration the laws of the state. And I wouldn't go into more detail. Chris would probably cover the rest of it. At the same time, just a reminder again, the structure of the program. So Chris will be doing most of the talking. This is the attorney Christopher Benson. And if there is anything that I need to comment on with regards to the Islamic perspective, where we have certain limitations, or how it should be done according to Islamic law, then I will comment on that. Whilst Chris is talking, I will interject and we will comment on that. And after each segment, Chris has a number of segments to present, covering various aspects. After each segment, we'll give the audience a time or a time slot to ask questions. And towards the middle of the program, we'll break, inshallah, for some snacks. And thereafter, we'll continue. And towards the end of the program, again, we'll round up with a lot of general questions, or people can ask questions in general relating to the whole topic that we have discussed today. Jazakallah khair, and I hand over the mic to Chris and we can continue from there. If you could give us a brief introduction of yourself and your experience.
Okay, thank you. First of all, I'd like to say thank you to Mufti Suhail and Muhammad Sheikh. Sheikh's been a great friend of mine for 20 years. And to give you a little bit of an idea of what we're going to do, we're going to talk a little bit about you, we're going to talk a little bit about me, we're going to talk about Washington state law, and we're going to talk about Islamic law as well. So, first, a little bit about me. So, I've been an estate planning attorney for 25 years, and for the past 2 months, I've worked closely with the Islamic Center of Redmond to craft something very unique. I've done over 1,000 estate plans for people in Washington. I have 4 offices. I have an office in Washington, I have an office in Oregon, Arizona, and in Idaho. And I can tell you that over the past 25 years, you okay? Yeah. Sure? You sure you don't want to talk some more? Because everyone's going to talk long, and you talk long for a long time. Okay, we've done over 1,000 estate plans, but what we've created in the last 2 months is very unique to handle the issues that you deal with every day. And that is, you're residents of Washington, you also have to follow Islamic law. And what we've crafted together is something where you can handle your affairs the way you are now, but also comply with Washington law. And that's the unique thing. That's what I'm really excited about. I've also handled more than 250 estates, people who have passed, who have not done the estate planning that they need, that we're going to talk about today. I've also done more than 1,600 transactions concerning real estate transactions. So, I do more than estate planning, but estate planning is my focus. So let's talk about you, right? Enough about me. Well, some of you have parents who are alive, and that's great, and that has implications under Islamic law if you were to pass before them, and we'll talk about that. Some of you are married. What we're going to talk about applies to people who are married, but also people who are single, and the protections that each of you need. Some of you have children. Some of you have adult children. We'll talk about that. And some of you have minor children. And so the concerns about guardianship, and if both you and your spouse were to pass, who is to take care of them, and how are finances going to be handled in that event. And we'll talk about that as well. Some of you have brothers and sisters. Once again, under Islamic law, that has implications. If you were to pass, not have a spouse, and not have children. Washington law, we really don't care about it that much. But under Islamic law, it does care. And we'll talk about how we can make it work together. Most of you have bank accounts. I hope you have bank accounts. Some of you own cars, right? Some of you own real estate. Some of you own real estate in this state, some in other states, and some in other countries as well. And what we've crafted together is a vessel that will avoid probate, make an ease of transition, but also it can own foreign bank accounts. It can also own foreign real estate. But we will talk about real estate in other countries as well and how that works. You live in Washington and you have to comply with Washington law. You also have to comply with Islamic law. And when I was talking about the requirements under Islamic law, I deferred to Mufti Suhail on this, and that's the unique thing that you have the opportunity, is you have the guidance of Mufti Suhail to guide you through the inheritance law. And you know, if you were to pass and your parents were alive, and the percentages of distributions to them, or if you were to pass and not have children, and the percentages to your siblings. So the big question is, how do you comply with Islamic law and Washington law at the same time? So that's what we're going to talk about, and that's the purpose of today. First, let's talk about tools. Okay? Well, what does that have to do with estate planning? Well, it has everything to do with estate planning. If it snows out, what kind of shovel do you want? Well, you want a big, lightweight shovel, right? So you can shovel off the driveway or the sidewalk and make the job easier. Well, if you're to plant a flower in your backyard or in your garden, would you use a snow shovel? No. You use a little hand spade. Makes the job a little bit easier. Now, you could use the hand spade to go shovel snow too, but that's not a very efficient tool. And that's what estate planning is all about. There's not one perfect tool that does every job. It's a collection of tools that accomplish everything that you need in your life. So before we started, somebody asked me, well, what do we charge to do a will? A will by itself isn't good enough, as you will see. Now, it's fine, because some people, in fact, over 60% of the residents of Washington, well actually, I shouldn't limit it to Washington, 60% of the people in the United States have nothing. They have no power of attorney, they have no will, they have no trust, they have nothing. And so when that happens, and we'll talk about this, you die intestate, and we'll talk about the law of that particular state determines what happens with your inheritance. Okay. So, what tools do you have in your tool shed? Okay. And that's what we're going to talk about. I don't expect a raise of hands, or because part of doing a trust and doing estate planning is privacy as well. But the benefit that you have with Mufti Suhail is that he is willing to review any estate planning needs that you have to make sure it complies with I'll make sure it complies with Washington law, he'll make sure it complies with Islamic law. So what tools are available? Okay? Well, wills. The problem with the will is that it requires a formal probate. So if you die, whatever you've written down doesn't automatically happen. It doesn't automatically go a share to your spouse, or automatically a share to your children, or different percentages to your children, or to your parents, or to your siblings. It doesn't happen by operation of law. What you have to do is you have to hire a lawyer, you have to file a probate with the court, and we'll talk about that. You have to disclose all of your assets, which most people don't like. You know, if I were to go around the room, and I'm not going to do that, but if I would say, hey, I want to go around the room, and everybody stand up and tell everybody else what you own, what assets you have, what real estate you have, your cars, your bank accounts, the amount of each bank account, and then also everybody you owe money to, and what you're going to do with it. Who's going to go first, right? Who's going to stand up? None of you. Nobody's going to stand up and do that. You know why? Because we like privacy. And that's what doing estate planning offers you, doing the trust. But with a will, when you do a probate, you have to tell the whole world because it's public record. We'll talk about that in a second. Revocable living trust. It's the best solution. It's the best solution for everybody, but it's really the best solution for you. And you'll see why as we go through the program. Directed to physicians. We used to call this a living will. This is if you're alive but unable to make your own medical decisions. You know, if death is imminent, do you want life support? Do you want blood transfusions? Do you want to be kept alive or not? And so what we provide allows you to make those elections while you're alive and competent and thinking clearly what would happen and what you'd want to have done. Powers of attorney. Now, in Washington, this changed in January 1st of this year, so your timing is very good. If you've done nothing, that's fine. A lot of people haven't. 60% of the people haven't. This seminar, and this educational seminar, offers you the opportunity to get things done. Well, the good news for you is the law changed January 1st. So there is a financial power of attorney that you need to have. There is a medical power of attorney. If you're unable to make your own medical decisions, well, who can make those medical decisions for you? It's not automatically your spouse. It's not automatically your brothers or sisters. It's not automatically your parents. So you get to designate who makes those medical decisions for you. A guardianship. You know, as thoughtful people, we're usually looking out for somebody else. You know, if somebody needs help, we help them, right? We don't think about us. Who looks out for us, right? So, we do a designation of guardianship. If you're unable to take care of yourself, who do you have in place to make sure that you've got a place to live and food to eat and clothes to wear, right? So we do a designation of guardianship for you. We're used to looking out for others, but you need to look out for yourself as well. And then we also talk about a guardianship with power of attorney regarding any minor children. So you get to select who takes care of your children if you're unable to take care of your children. All right, so here we go. Wills and probate. I'd like to say it's something super complex. It's not. Okay. A will speaks at the time of death, but you got to die, right? So you write down things on a piece of paper, what you want to have happen, and each state has special requirements. You know, it's got to be witnessed by 2 people that aren't family members. It's got to be notarized. It has to have certain language in there, but you can kind of fake your way through it, right? I mean, the internet, I have a really high rating on the internet, so if it's on the internet, it must be true, right? So you can go on the internet, you can get a will, right? You don't need me for that. You can fake it yourself. It might work, it might not. Are you willing to take the chance? And why should you? The purpose is this is your last act on earth to tell everybody else what you want to have happen. Are you willing to roll the dice and take chances? Maybe it'll happen, maybe it won't. Or you want to make sure that it'll happen. You can go on the internet and find out. You can download a form. You can write it out yourself. Okay? But the deal is that whoever the executor is named in the will has no legal authority to act until you die. You've got to die first. Judge enters a court order granting the executor the authority to act, called letters testamentary, even if you are married. So people think, oh, I'm married, I pass. My wife gets to handle everything. That's not true. It doesn't happen automatically. And it doesn't happen unless somebody files the will with the court, and somebody makes a court appearance, and a judge says, yes, you're authorized, and the court of that jurisdiction issues these letters, it's called letters testamentary, that you can provide to the bank or real estate broker or whatever. Until all that happens, nobody has the legal authority to act. So what we deal with on a monthly basis is a common misconception of the surviving spouse. The misconception is this: if I have a house, if I have a bank account, if I have a car, and I die, everything automatically goes to my spouse. And it's false. It's not true. Now, Washington is a community property state, and a lot of states in the West Coast are community property. What does that mean? It means that if we're married and we acquire something together, it's presumed that both of you own it. Well, if both of you own it, that means you own 50% and your spouse owns 50%. Now, you can take action where a spouse does not own it, even if it's acquired during the course of marriage. We'll talk about that in a minute. But even if it is owned together, the spouse, just because they lived longer, doesn't mean that they get everything. You have to actually do a probate. You have to hire a lawyer. You got to file it with the court. You have to do an inventory. You have to tell the whole world all the assets that you own. You have to tell the whole world all the debts that you have. And most people don't like that. The advantage of a will is it's simple. You can download it from the internet if you want to. It's simple to do. You can write it up, you can sign it. Maybe it's good, maybe it's not good. So it's easy to do. The disadvantages are probate is expensive. And I kind of started this topic off with saying, well, I'd like to tell you some big mystery. There's some concepts that are very simple, but they're difficult to execute. I'll give you an example. If I was going to, I said, well, I want to go to the moon tomorrow. Simple idea. 7 words, right? Going to go to the moon tomorrow. Execution, a little more difficult, right? I got to get a rocket, I got to get a helmet, some food. So execution is a little more difficult. So probate, it's not a huge mystery what you do. You hire a lawyer, you file a petition, you do your inventory, you tell the world about all your assets and all your debts. You get a court to say that's okay, and then you go about the process of moving title from the deceased person to the living people. Now everything has title. This laser pointer has title. This building has title. The cars outside have title. Bank accounts have title. Title just means ownership, right? So the purpose of probate is no mystery. All we're doing is if you die and you own title when you die, you can't use that stuff anymore. You can't spend the money anymore. So we need to take the money from the deceased person and give it to somebody who's alive so the living person or people can use the money. And the real estate. If you die and you own real estate, a fractional percentage or 100%, you can't use the house anymore, right? So we've got to take title and we've got to move it to somebody who's alive because people that are alive can live in the house. That's it. It's not rocket science. The problem is that it's expensive and takes a lot of time to do that. The second thing is it's probate's public record, like we talked about. It causes a delay to access to your financial accounts. And the reason is that the executor, whoever gets appointed by the court, cannot distribute money to your heirs until all the debts are paid. Okay? And there is a 4-month waiting period on the notice to creditors. So, you pass, you hire lawyers, you file with the court, you make your court appearance, you get appointed by the judge, publish notice in the paper, and then you got to wait 4 months. Now you can pay, the executor can pay administrative expenses. What does that mean? I mean, pay me, that's cool, I like that law. But you can't give any money to your kids, you can't make any charitable donations, you can't give it to a spouse until make sure all the debts are paid. A will speaks only at the time of death. It does not allow someone to step into your shoes or manage your assets for your benefit if you're physically or mentally unable to. And that's what we're seeing now. You know, a lot of you are really young that are in the room today. And I've been doing this for 25 years. And, you know, from 91 through, 2008 or so, we would kind of talk about this concept of being, becoming incapacitated. What if you got Alzheimer's or dementia or whatever it is? And it would come up 2 or 3 times a year, not that much. Now, I can tell you, we deal with that every week. Every week, somebody comes in my office where I did their estate plan 15 years ago, 20 years ago, and they say, thank you for doing the estate planning for us, because I never thought it would happen to me, but it's happened to us. Husband, wife, now has dementia, unable to manage their financial assets. In fact, to me personally, it's happened as well. My mother-in-law, well-educated woman, she's authored books and articles. 16 months ago, she was fine. She was fine. Last Monday, we moved her into a dementia care facility, unable to manage her assets. Thank goodness she'd done estate planning, that she had her son in place to be able to manage her assets for her. So what we're seeing is people living longer with their body, but their mental capacity slipping. So a will does not handle that scenario. Also, the issue of if you have minor children. If you have a will and you die, and let's say you name your children in the will, well, who's going to manage their money? Well, what you're stuck with is if they're under 18, and maybe you don't want your kids to have money at 18, maybe it's 21, maybe it's 35. Maybe you want to change your mind along the way. But let's say you pass and you have minor children, who's going to manage that money for them? Well, guess what? The money has to be held in a trust for their benefit and then managed by a trustee. But you could have skipped that step doing your initial planning. You could have just done a trust and made those provisions up front. So it's very expensive. It's not complicated, but it's very expensive to get. Okay, a revocable living trust, the best. You may have any questions. Let me ask you that. You may have a question about will or the probate process. And the way these questions are typically asked are, I know a guy who has a friend, and this happened to them, and then we know it's about you. Right? So nobody wants to ask a question for themselves. Yeah, go ahead.
You mentioned that everything has a title, and it doesn't mean that spouse automatically get the ownership of that.
That's right.
But on the title, if you have co-ownership, like a bank account where it's a joint bank account,
Yep.
that particular thing doesn't have that issue.
Okay. So why don't you
repeat the question?
I'll repeat the question.
And then next time onwards, whoever is asking a question, just go up front and
yeah,
ask.
let
That'll be
finish them,
easier
then
for
ask
us and
question.
save time, inshallah.
Because no, this question is not complete question. Let them complete the lecture, then we ask question.
No,
he's
this
taking it right
is
now.
interactive. I'm good with that. I asked the questions. So his question is, I said that everything has title, and that's true. This laser pointer, the computer, the building, everything has title.
No, what you are explaining here, the advantage and disadvantage, is it restriction and limitation of the law in this country?
In what part?
You are explaining all this distribution of the wealth.
Right.
This advantage, disadvantage, this should be done, this should not be done. So is it this are restriction and limitation by the law here?
Yes, and I'm going to answer your question.
Mm-hmm.
Okay. I know what you're asking. What you ask is, he says everything has title, but what if you have co-ownership? Okay? Both of us own it. It depends, and that's a lawyer answer, right? It depends. One of my best friends is a psychologist, and he says, hey, being a lawyer is the easiest thing in the world. I said, why is that? He says, because when somebody asks you a question, you always just say it depends. Sometimes it does, it depends. So we can own this thing as co-owners multiple different ways. We can own it as joint tenants with the right of survivorship. And what that means is that whoever lives the longest gets it. But it's got to specifically say that, joint tenants with the right of survivorship. We can own it as tenants by the entirety if we are married. And what that means is that if one spouse lives longer than the other spouse, then the surviving spouse gets it. True. Most common in Washington is tenants in common, which is the word tenant. Here's another thing about law. You're learning more about law than you care to know. We ran out of words. So we had to use some words twice to mean totally different things, right? Tenant doesn't mean landlord-tenant. It means co-ownership in certain circumstances. So as I go through this and I talk about trusts and I talk about estates, sometimes I'm going to use the word in a different context and it's going to mean something different. So I'm not done with your answer yet. Hang on, man. We'll get there. I grew up on the Navajo Indian Reservation in New Mexico. Not that you care, but I did. And my last name is Benson. And the closest word in the Navajo language to Benson is Debebetson. Okay. Debebetson means three different things depending on who you are and where you're at. So, if I'm a man talking to another man and we are next to a tree, it means sheep. Okay? If I'm a man talking to a woman, oh, are they over there? Yeah. A woman, it means skinny sheep. If I'm a man talking to a man and there's no tree around, it means sheep bone. Okay?